everybody, and welcome to John's Rants. I'm John Giardinelli, Association Counsel. I am going to be covering a couple of topics today, more to give you a head start on what's going to be happening in December and January. We're going to have a number of new forms, and of course, as is typical, we'll be doing an association newsletter for you on all the new forms. But I want to give you a little head start on a couple of them that I think are really pretty significant. And then I want to talk to you about the new law for mandatory buyer representation agreements, because it is no longer simply an MLS rule. It is now going to be a state statute, and it's going into the Business and Professions Code, which means if you violate it, you could conceivably have a problem with your license in the Department of Real Estate. I'm going to give you a heads up on a conversation we've had with the commissioner's office, and just kind of bring you current. So let's talk about that one first. So we've been talking about Assembly Bill 2992. This is the bill that would require that a buyer representation agreement be executed between a buyer's agent and a buyer before representation actually commences. It is mandatory. And it has now been signed by Governor Newsom into law to go into effect on January 1st, 2025, 2.5 months from now. So what is it all about? Well, as you know, under the current MLS rules and under the NAR settlement with the plaintiffs in the class action lawsuits, a buyer representation agreement is mandatory if you want access to any of the listings in the multiple listing service. You're required to execute that buyer representation agreement prior to touring the property. And of course, if you fail to do so, you could be subjected to a $2,500 fine. And of course, the buyer could claim that your representation was based on false representations. Under the new statute, which will go into effect on January the 1st, as I mentioned, the requirement for a buyer representation agreement will now be mandatory for virtually all properties, not just properties in the MLS. It will apply to all licensees. It will apply to residential 1 to 4, multi-unit, vacant land, commercial, ground leases coupled with an interest, and manufactured homes. It will not cover leases or rental agreements, but there are CAR forms dealing with how you get paid in those situations. It will not cover any federal land sales, and it will not cover loan brokering, only representation on the buyer side. You must have it executed as soon as practical, but no later than when you write up an offer. However, because the statute says that any representation without a written agreement is void and unenforceable, if I work with a buyer and I show them a bunch of houses, and under the BRC, I would otherwise qualify to be broker involved and therefore potentially entitled to compensation, but I don't have a buyer agreement. So I go into a house. I do virtual showings. I provide a lot of information about the neighborhood, help them to create an offer, but we don't write up an offer and they leave me. I'm potentially not entitled to compensation. Whereas if I get that agreement signed as soon as practical, and again, there's going to be a regulation from the Department of Real Estate, and we're actually working with the Commissioner's Office, myself and a couple of other lawyers, to come up with the proper language for what is practical. But if you look at the standard definition in any of the dictionaries, you'll see that it's basically as soon as practical. It means as soon as possible, subject to any intervening problems. So if I'm working with a buyer and I'm a real estate professional, and I put together a lot of information. We make arrangements to go see properties, either virtually or live. We do a bunch of stuff together. I'm going to have a hard time explaining, particularly once the regulations come out, how I wasn't able to get a signed buyer representation agreement pretty much right away. So I think that's going to be a big issue going down line. Bottom line is that if you're already using buyer representation agreements, particularly the BRBC, which is the CAR form, you're in great shape, because that form does comply with the statute for all purposes. So whether it's an MLS listing or an off MLS listing or commercial or vacant land, whatever it's going to be, if you're using a BRBC, you're going to be in great shape. If you're using one of the other forms that has been introduced in the marketplace, you need to make sure that your lawyer takes a look at it and make sure that it complies with the new statute as well. So that's going to be a really important issue. We're going to be hammering on that whenever we're given an opportunity to speak to you, and we're going to be participating and keeping you abreast of what the actual regulation will be. Problem with the regulation is the statute goes into effect on January the 1st, but by the time the regulation goes through the bureaucracy, probably won't see a regulation till early March of next year. So we're going to have a little bit of a gap. But I would urge you to continue to use the BRBC for all purposes, or some other valid, compliant buyer broker agreement, and that you do that for all purposes for all times. The contract is going to be for a limited period of time, cannot be for more than 90 days. That's going to be in the regulation. We had a meeting last week, and because there was some ambiguity, it's going to be 90 days, and it's going to be 90 days from the execution of the agreement. So if the 90th day falls on a weekend or a holiday, too bad. It's going to be 90 days, period, end of story, unless the regulation changes. But as of today, that regulation will say 90 days, period, end of story. It can be renewed. However, it cannot be automatically renewed. In other words, you can't put together your own contract that says something to the effect of, unless otherwise canceled, the contract automatically renews for an additional 90-day period. That is an invalid extension. You have to actually have a signed, dated, written extension before the 90 days expires, and then you can extend it for another 90-day period, although the buyer may not want to do that. That's why if the contract is terminated at the end of 90 days or sooner, pursuant to the terms of the agreement, you need to make sure that you get out that broker involved property form so that you can protect yourself if you showed a property that the buyer ultimately purchases. And by showing the property, I mean complied with the requirements for broker involvement. Again, so the renewals can take place. The contract, and of course the BRBC does all these things, requires that you define compensation that's going to be paid to the broker, services that will be rendered, when the compensation is due, and generally it's going to be due through escrow funds at the close pursuant to the BRBC, and it requires that there be a specific termination date no longer than 90 days hence. You will be required, and the BRBC will be bundled with a agency disclosure. So again, you're creating that agency relationship much earlier than ever before. The statute does indicate that a buyer representation agreement that is made in violation of the new statute is void and unenforceable. So clearly the existence of a buyer representation agreement is void and unenforceable. And It is going to be considered a violation of the licensing law, which could lead to issues relating to your license, its revocation, its restriction, or other problems with the Department of Real Estate, which you certainly don't want. So again, you want to make sure, and we'll continue to pound into you as the association allows me to do so, what the requirements are, because this again amends the Business and Professions Code, so it becomes part of your licensing responsibility, not just part of your civil obligation. And then lastly, and the BRBC does provide this, there must be a statement that all of the commissions are in fact negotiable. So that goes into effect on January the 1st. It amends both the Business and Professions Code as well as the Civil Code. So that's basically it for that. Again, there'll be a lot more information between now and the end of the year, and even after the year commences, when the statute goes into effect, because we'll be letting you know what the status is of the regulation, what it's probably going to say, and all of that. So keep in tune with the association so that they can keep you abreast. In talking to the commissioner that will be drafting these regulations, there's also going to be an education component. Obviously, the association will do its usual bang-up job in getting you information relating to these important changes, but the department will also be issuing notifications and other information. And they've also indicated that while they're going to enforce this law, if you make a mistake, you know, and we're all human, we all make mistakes, and it's a mistake. It's a legitimate mistake because you're trying to interpret, maybe sometimes in some cases overthinking what you're supposed to do. Yeah, they're going to be a little more lenient on you for the first couple of months. Whereas if you commit an egregious or intentional violation of this statute, you can expect that your bad behavior will be punished accordingly. And again, keep in mind that if you violate the MLS rules for access by not having a written agreement, you're subjected to a $2,500 fine by the MLS alone without warning. So this is important stuff. We'll keep you posted. Now, as far as new forms, in December, probably the second week of December, going to have a whole bunch of new and revised forms. There's a couple of changes that I think are really significant. Now, I'm a little myopic in my viewpoint because I'm your lawyer for the association and for some of the brokerages within the association. But I think these are good and important changes that will be taking place. Right now, if I make an offer using the residential purchase agreement, and I want the seller to consider contributing to the buyer's compensation as set forth in the buyer-broker representation agreement, the way I do it is I check off in the matrix, I think it's paragraph 3G3, asking as part of my offer that the seller pay a portion of the buyer's compensation to their broker as a concession or as a cost that I'm going to help carry. I would then have to provide a form called the seller, the SPBB, the seller payment of broker, buyer broker compensation. And we've seen, and CAR has seen lots of mistakes. People forget to include that form. They predate it. They post-date it. It's a mess. So what they're going to do is they're going to take the SPBB and they're going to put it in to the matrix and then sunset the SPBB. So from now on, when you write up an offer, in the offer itself, you will be saying, please, a part of our offer, we're offering you X amount of dollars terms. We'd like you to pay some of the buyer representation, and then you will list out either the percentage you want them to cover up to the entire amount that the buyer has obligated themselves for, or the actual dollar figure. And if they agree to that, then you've got a deal. If they counter it, then you don't have a deal until you accept the counteroffer. But that's going to be part of the RPA, so you won't have to have a separate form. So the only other thing you'll need to send with your offer is page 5 of your BRBC, which confirms how much the buyer has obligated themselves to pay. So there's confirmation of that. And they're actually probably going to put some additional language in either this upcoming draft or the June draft to make that even more clear. I'm constantly being called about problems relative to the expiration of an offer. If you read your contract, it says that the offer generally will expire in 72 hours, and then you can fill in another date. But we all know that things happen. You know, you go back and forth, the counteroffer doesn't come in until 4 or 5 days, maybe the seller's gone, maybe they've delayed getting together with their agent, and then they counter, and then it's accepted, but it's past that 72-hour period. That's always creates a question, do we have a valid contract? And they're going to take care of that for you, because the counteroffer, all of them, the buyer counteroffer, the seller counteroffer, the multiple counter, all the counteroffers are going to have language that says that if a counteroffer is accepted, the expiration date is deemed to be not applicable, so that you will clearly, without any argument, have a contract. So I think that's going to be a good change. And then I just had this case actually just a couple of weeks ago. I'm the buyer's agent. Well, the BRBC is actually owned by the brokerage, although I've probably, as the buyer, never met my broker. I have no relationship with the brokerage. I only have a relationship with the agent, and the agent decides to move to another office. What happens to the agreement? There are a couple of issues there. Number one is I'm the broker for the office that's losing the BRBC. I want to make sure that I'm not going to be liable any longer for any of the acts of the new brokerage. And number two, I'm interested, I've spent money. We have an offer. We represent a buyer. We've done some training. I want a referral fee, and there's language going to be, so there's going to be a new form. It's the transfer of buyer broker form, and it's a form that will allow the transfer of the listing to the new office, subject to the agreements that are checked off that say, I'm not liable for anything past what the date that it's transferred. We're going to talk about a referral fee that I would like to have, and all the things that may become a dispute. You guys can resolve that, always keeping in mind that you are acting in the best interest of the client, but nevertheless, you're entitled to be paid. You're entitled to not have any further liability, et cetera, et cetera. So there's a new form coming out that will take care of that for you. There's also going to be some additional forms confirming buyer broker compensation. There's going to be a form that will allow you to put together an estimate of what those costs are for the buyer, including closing costs and the like. Again, there's going to be some changes to both the agency disclosure because of the new buyer representation law. There's going to be some changes to the some of the financial forms, making it clear that you have to have a written consent of your client to reveal any of the confidential information. There's going to be forms dealing with commercial contingency removal. And we're going to go through all of these for you in a newsletter that'll come out probably towards the end of November. So once we know that these forms are final, and some of them are still in draft format, but as soon as we know, there's going to be a meeting later part of this month or early next month where they're going to finalize everything. Once that happens, they'll notify us. We will then do a newsletter and keep you guys current. All right, lots going on. Not to mention, of course, the NAR settlement goes to a hearing on November 26th. We are currently in the objection period. That expires on October 26th. So we'll know if there are going to be any objections by the Department of Justice, by any of the copycat plaintiffs to any of the settlement between NAR and the other brokerages. Hopefully that will take place and the settlement will be approved on or about November 26th. All right, kids, that's it for today. Hopefully this information is timely and helpful, give you a little head start on some things. We'll see you the next time on John's Rants. You guys take care.